Good afternoon, my name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about adjustment of status before USCIS and what every applicant for adjustment of status should know. And of course, we're going to also focus on new updates to USCIS policies regarding adjustment of status and exercise of discretion when USCIS is adjusting one's status to permanent residency. So adjustment of status is the process when a person applies for a green card within the United States. Of course, it's possible to receive an immigrant visa when you go for it in a consulate overseas. But if you do the same thing, or relatively the same thing, within the United States, while you are in the United States, that process is called adjustment of status. And generally speaking, to adjust one's status in the United States, you have to watch out for eligibility. First of all, what is the ground for your adjustment of status? Is it a family petition, employment petition, special immigrant juvenile petition? Can it be approved? Has it been approved? For example, if you're filing for adjustment of status based on a family petition, make sure you're not going to be precluded from receiving adjustment because your new family petition is not going to be approved due to a 204C bar. I'm referring to a very strict and very heavy bar on adjustment or rather on approval of any type of petition for someone who is believed to have committed in the past marriage fraud, 204C bar. So in any case of adjustment of status, even if it's a child sponsoring a parent, for example, or a new spouse is sponsoring a spouse who's a non-citizen, make sure that in a person's history, there will not be an issue, and there was not an issue, and there will not be an issue of 204C potential fraudulent marriage situation or accusation. Of course, that's the grounds, most common grounds for adjustment. Then we're going for bars to adjustment. Let's say your ground for adjustment is approved or can be approved. There are no obstacles to that. What about the bars to adjustment? Can you, after the ground is approved, receive the green card in the United States, legally speaking, right? For example, if you have certain convictions in your record, if you have fraud in your record or can be accused of fraud, usually it happens, for example, because you submitted some previous applications that had contradicting information, or maybe you've submitted visa applications when you were trying to come to the United States that had some not true information or contradicting information. It doesn't have to be fraud, remember. It can be also material misrepresentation, meaning that something that was incorrect due to, let's say, without your intention to defraud somebody, but there was a material misrepresentation. It affected your eligibility for the visa, okay? So watch out for that stuff. Public charge is one of the bars to receiving a green card. If the government believes that you will not be able to support yourself in the United States, and public charge bar may be applied in some situations, and in some situations it does not apply. For example, if a person is filing for adjustment of status based on a VAWA ground, violence against women ground, or special immigrant juvenile petition, then public charge bar does not apply to a person at all. So all this analysis should be performed before a person is filing for adjustment of status. One of the bars that a person may encounter is the person's inability to prove legal entry to the United States. Inability to prove that the person was paroled or was inspected and admitted before he or she came to the United States. And sometimes it's a legal inability rather than factual. For example, a person was paroled but that particular parole now does not count as a legal entry for adjustment of status. So it's one of the things that a person should watch out for. But those are the things that I spoke with you about. They're more or less stable. It's rather they exist or they don't exist in your file. And with a good preparation, if an attorney is working with you, an experienced lawyer is working with you, a lawyer will be able to, in 99% of the cases, if you're truthful with your attorney, lawyer will be able to predict whether this will become potentially there is a problem in your file or not. But now there is one more layer of adjustment of status that recently has been codified in USCIS practice manual is discretion. Is discretion that it's USCIS refers to it as grace that the government is using when they're determining whether or not to give a person a green card. Okay. So after you met all those legal requirements I spoke about earlier in this video, okay, USCIS is going to now look at negative factors in your case and positive factors in your case and decide if you deserve the green card in the United States. So let's go over those factors, positive and negative, that now USCIS is going to be taking into consideration. I understand it's going to be a necessary step in the analysis when they are determining if to give you a green card or not. And you should know about that because this will dramatically affect your ability to receive green card in the United States. So even if you have that real marriage, for example, all right, even if you have that employer who filed and whose employment petition was approved for you, you still have to go through this analysis. Your case will go through that analysis, and it's good to know what those factors are, right? So let's talk about them. Well, first factor that the United States government is going to look at is family and community ties. Family and community ties, meaning that do you have family members in the United States? Children, spouse, parents, or not? I'm not really sure how much weight that particular factor has, especially in the case of, let's say, a refugee adjustment. Well, refugee adjustment actually does not use discretion at all, but let's say asylee adjustment. But that's one thing that you need to remember, that your family status and family ties in the United States will matter, okay? Immigration status and history. Here, the government is going to look at if you previously violated any of your immigration statuses that you had. For example, you were a student and you decided not to go to school, you didn't pay your school bills. Let's say you engaged in unauthorized employment, right? If you violated any immigration laws, let's say committed fraud, immigration fraud, if you have an unexecuted order of removal. Those are the factors that are listed in the USCIS practice manual. I'm not making this stuff up. This is what is going to be looked at. Then, business ties. Another factor that the government is going to look at is business ties. Do you have business and property in the United States? Employment history. Your education and special skills. If you don't have stable employment, if you exhibit patterns of unemployment, if you had some illegal income from illegal activities, alien smuggling, gambling, some sales of some not good substances, I understand, controlled substances, then it will be a heavy negative factor in your history that may prevent you from receiving green card in the United States. Then the government is going to look at, and this is one of the most loose factor, I would say, community standing and morals. Okay, if you have high morals, if you exhibited a high regard to the law, respected the law, if you complied with your tax obligations, watch out here. It means that if you may have a heavy tax debt or didn't file your taxes, you show that you've been working but did not file your taxes in the United States, that will be a negative factor in your adjustment of status application. If you show that you're a danger to public safety and national security, and if you failed to comply with civil court orders, and of course if you didn't pay child support. Let's talk about the civil court orders. It means, for example, that you were sued by someone, right? And you have judgments. Maybe you have some liens, judgments, and things like that. So if you did not pay it off, it may affect your green card application. Together with failure to pay taxes, very important, right? I hear so many times when people are saying, but I don't have any prospects of any status. Why do I have to pay my taxes? Well, if you work in the United States, generally you need to pay your taxes. That's how it works. You need to find a way to pay your taxes. You should speak with a certified public accountant. And now, by the way, this has been put in the law, in the regulations, okay? That if you didn't pay your taxes, you may be precluded from receiving adjustment of status. Very, very important. Compliance with the tax law. And also, of course, there is this category of criminal convictions and recent criminal activity. What's happening here is that sometimes when you're convicted of a crime, it becomes a problem for your adjustment of status. But what they're referring here are those small convictions that didn't rise to the level of a bar. By itself, they do not preclude you from getting a green card. Nevertheless, your criminal history can be taken into consideration, and the government may determine that you do not deserve adjustment of status in the United States. Well, I hope this video is helpful to you if you're filing for adjustment of status, considering filing your application, or if you have an application pending. And please like, share, subscribe to my channel, and I hope to see you soon.